necessarily objecting to the contents, all of them, but it's essentially rooted in lack of legislative competence of government in terms of Article 191. And the argument, my lord, is judiciary is some schedule part 1 clause 3 is there any difference between
sadly in the
Now, the other limb of appeal. Fundamental rights. Public importance is variable. Let's stick to fundamental rights. So the power here is not a much larger power. So my reading of the Constitution, a much narrower power than the High Court. High Court may strike down this law, arguably, and then we can sit in 184 as an appeal. Then we have more powers. I don't know. Am I wrong in my understanding?
That's correct, my lord. And my lord, as far as challenge to the vires of this law.
Just to add to that, where a law deals with powers of this court, the Supreme Court of Pakistan, do you think it would be appropriate for the High Court to adjudicate upon it?
My lord, in another proceedings, this is a submission that I had made in other judgment where a specific question was raised, and my submission, respectful submission at that time was that yes, and I maintain that position.
But are you aware there is a judgment of this court which says otherwise?
My lord, now I'm before a full court, so I'd just, based on that, I'd just proceed. My lord.
I know you press for time.
Attorney General, can you explain the word enforcement? It's not the infringement of the fundamental right. It's the enforcement of the fundamental right. So,
public importance with reference to the enforcement.
Here, fundamental, public importance, fine. Both parties are there. Now, had it been infringement, then you were right that there has to be a right which was infringed. Here, it's more wider. It's enforcement. They are saying that this is a matter which relates to to access to justice. So it's an enforcement of that particular right that they're talking about. They're not saying that it's an infringement of the fundamental right. Can you explain? Can you expound on that?
My lord. Now, of course, as I said, my lord, I reiterate that yes, access to justice is a right recognized by this court covered under Article 9, and to that extent, yes, it would be a fundamental right. Now, what they had to show was, the burden is on them, while challenging the constitutionality of this act on the basis of lack of enforcement of fundamental right, as my lord has just pointed out, not infringement of right. What they have to show is that this law does not, in fact, enforce this right of access to justice.
No. It's first we are at the threshold of the maintainability. We don't go into whether this is right, whether it is wrong, whether it is enforcement of the fundamental right or it is an infringement. As far as maintainability is concerned, public importance is done. Then we come to this issue of, does the petition that they have filed, does the petition talk about enforcement of the fundamental right?
To become a question of public interest, it must apparently prima facie be something against public interest, and then you say, yes, it's a question. But if it's so obvious that the whole law is in public interest, for example, do you think there's a threshold to that effect, or there isn't any?
My first part of my submission, my lord, was that the question of public importance, my lord, when I pointed out that what this law does is it democratizes this institution, brings more transparency, structures the discretion, it actually advances that public interest.
Attorney General.
And therefore, they fail on that threshold, that count as well.
Attorney General,
my lord.
on my repeated questions, in response to my repeated questions, they conceded very explicitly that this is a good law. It enhances access to justice, and also, speaking for myself, it addresses a very, very big issue of internal and institutional independence. Now, in that context, when this is an admitted fact, the only question whether the parliament had the competence or not, क्या जो 184(3) की requirements हैं, वो fulfill होती है? Because there is no enforcement of fundamental.
Lord, if that is so, then these petitions have to be rejected on this basis alone. Legislative competence is concerned, 184(3) cannot be pressed into service.
So taking
If we'll let you, I think a lot of questions are coming up. We'll note. I'll try to make a point.
These are, my lord, please.
But अगर आप थोड़ा सा अपना continue रखें, I want to know where you're going. Okay.
Attorney General, if I may ask you a question, is the public interest that Parliament, or for that matter a provincial assembly, remains within the limitations that may be placed by the Constitution on Parliament or a provincial assembly? Is it in the public interest?
My lord, which fundamental right would it
Not
be
talking of
affected?
fundamental right. I'm talking of public interest.
Of course.
Of course.
Yes.
So therefore, If a law,
Again, happening, which I must, interject. I would, with you have agreed. Now here, I won't agree with you. I will say it may be unconstitutional, but not within the parameters of 184.3. There may be a lot of unconstitutional things going on in Pakistan, but it won't come within the parameters of 184.3. That is the fundamental point. That's my way of approaching it. Others have different ways of approaching it. So I think आप जरा चलें फिर आप नोट कर लें सवाल.
I just this part I just
if I may continue, sorry, if I may continue. It is in the public interest, right, I'm only speaking of public interest. It is in the public interest you accept, and I think rightly so, that because we have a federal structure, Parliament and provincial assemblies must remain constitutional limits, right? Whatever those constitutional limits are. So therefore it seems to me to follow logically that if Parliament makes a law that is ultra vires, or a provincial assembly makes a law that is ultra vires, it is in the public interest to challenge that law. Because if remaining within the constitutional limits is in the public interest, then going beyond those limits and making an ultra vires is surely a breach of public interest. What would you say to that?
That touches upon the legislative competence.
No, I'm talking of public interest.
Yes, but
Yes,
but
is it
any
in the-
law, a law
is
cannot
it
be
in the
struck
public
down on the
interest?
basis of just
Where,
being public.
where the challenge can be is a separate.
Well, Lord, let's just take a step back. Any law made by any legislature, provincial assemblies or the parliament, would be a matter of public interest and importance. It is a law that is being enacted. Now, in order to examine that law, in order to assume jurisdiction to examine that law, we have to look at, in the case of Supreme Court, Article 184, and the cases of High Court in 199.
नहीं, आप
Now,
देखिए, आप तो कह रहे हैं ना, मैंने जो नोट किया हो सकता है मैंने फिर गलत नोट किया हो. आप तो कह रहे हैं कि this challenge fails public interest and this.
जी.
तो मैं अभी सिर्फ public interest पे देख रहा हूँ ना.
But
तो मैं आपसे पूछ रहा हूँ, I mean, speaking for myself, it seems to me that any law which is ultra vires, whether by parliament, whether by provincial assembly, meaning breaches the limitations, whatever they may be, imposed by the constitution, because the constitution is supreme. It is contrary to public interest. Has to be.
Now, let me just quickly address this because this is a maintainability issue here, and I want to address that issue here first and foremost. The two conditions provided under Clause 3 or required under Clause 3 are connected. It has to be a matter of public importance with reference to enforcement of fundamental rights. Now, independently, any legislation, any statute, any rule or any regulation would be a matter of public importance or public interest for that matter. Now, in order for this court to assume jurisdiction, now this court does not assume jurisdiction under 184.3 on a legislature, on any law being enacted for want of legislative competence. It has to be ultra vires or violative of the rights, fundamental rights granted.
So you say that the word relating to enforcement,
With reference to the enforcement of.
that you say is the buckle that connects the two things.
That is the buckle that connects the two, and that is where it actually prevents, if I may say so, this court to examine constitutionality of a statute on legislative competence.
Is legislative competence not in the public interest?
As I said, Your Ladyship, this is something, legislative competence alone is something which can only be examined under 190.
Is it not a right that everyone has under the Constitution
My Lord,
that laws are
legislative-
made in a particular
The
way?
legislative competence, of course, as I understand it, what you have to see in the act is an act of parliament, whether Article 70 read with the list permitted it or not, or whether there is a provision of the constitution which directly confers that power upon the parliament, whether that provision permits it or not. And if those provisions do not permit that legislature to legislate on that particular matter, then yes, this is a legislative competence issue and it is not permissible under 184.
In your opinion, the law is good law, Parliament is competent to make the law, and every provision of the law is valid and does not in any way violate any provision of the Constitution. So then what happens again? I go back to the full court hearing aid, and you are given a right of appeal under that. So are they not then entitled to their right of appeal in the event that the court decides that these petitions are not maintainable? They cannot challenge it. Does that not go to the fact that once again you've put the burden on the court itself to decide when it wants to constitute a full court and block that right of appeal?
Looking at it, because someone files an appeal, yes, it may bring in litigation into the court. That's the downside, may be said. But where is the aggrieved person? Who will be the aggrieved person be? The person affected. Because I think the 184.3, the whole intendment of that was for not for lawyers. It was not for the well-to-do. It was not for the multinationals. It was for the poor, the dejected of society. We have a whole chapter on the principles of policy, which nobody bothers to, we don't read. Bonded laborers, transgender, women rights, children, they can't come to court. We can intervene, 183 can come to their rescue. So I was looking at things in that perspective. We have to see the whole entire constitution as a whole. We just stuck with one provision that somebody says, hey, please tell me how you aggrieved. I kept asking him, are you aggrieved? He says, no. They couldn't do it, you can do it. That's about the argument that I've understood so far. That's a valid argument on its own. Yes, to be addressed, for instance, the income tax ordinance has certain that have been challenged before the High Court. Could we entertain it on 184.3? After all, it is legislation. After all, it's a public interest. After all, it's a taxation matter. It will meet all the tests of public interest. But it is not, because taxation is not a fundamental right. You can't tax or not tax or whatever. Nobody can say my right not to be taxed has been infringed. So go through the High Court route. 181 petition, come to the Supreme Court in 184. That is the appellate jurisdiction. So we should read the Constitution and not just pick the words. We are just stuck with these words, 2 words also. Who's harmed by this? The only thing is you've taken away our power. You've taken away specifically the power of the Chief Justice. That's one irritant. You've given a right. That's another irritant. You have created another same lawyer. Okay, this person wants to waste money on another lawyer, do so. So his power will be lighter. What is it to us?
आगे बढ़े थोड़ा सा. Mr. If I may, take you back to what you were saying about, and I understand your point relating to the buckle part of it. So here we have a law which relates to the practice and procedure of the court, and that is, you say you accept that any law which is ultra is against the public interest, but you say the buckle is missing because it's not just legislative competence alone, but it has to relate to fundamental rights. So I was just wondering.
If I may rephrase it before my Lord formulates the question. Legislative competence cannot be interfered with here.
No, I'm just saying, I understand that.
Yes.
So he may care.
Yes.
But breach of legislative competence is contrary to the public interest. The subject matter is legislative competence in relation to practice and procedure. Surely, as a matter of principle, it's not a question of whether the law is taking away. It is this due process in and of itself? And if the law is ultra vires, the answer is precisely because ultra vires, it can't be due process.
So let's proceeding on this.
Whatever it says, whether it says
I'll go with it.
Chief Justice is master of the roster or five.
I'll go with it, and let me
just
make my submission on this. I'll go with it. When somebody brings in, and let's assume, for the sake of argument, let's assume, and for a moment, if it is assumed that yes, it is a matter with reference to fundamental rights as well, then what has to be shown in the first instance is that this legislation fails to enforce or infringes any of the fundamental rights that the citizens may have.
Well, if due process is interfered with, surely
They have not shown anything to say that there is any due process which they are entitled to under the existing scheme or the scheme as it stood prior to this act.
We made our questions. You can continue. But I think we have our own views and opinions. आप चलें आगे.
My lord. Now,
you have to persuade us, not we have to persuade you.
Just one question I was just thinking about it. Suppose a provincial assembly or even the parliament tomorrow makes a law saying after an appeal has been pressed under Article 185, another appeal would be available to the litigant before a larger bench. Would that law stand?
I would rather consider these.
Competence की बात कर
Let's consider law did. Maybe tomorrow that very matter comes before us.
So the question is.
A second appeal. My lord's question is whether the second appeal would be provided.
Not at all. I am questioning the competence. The appeal in the Supreme Court under 185 is provided by the Constitution. Can another appeal, which is not specifically provided in the Constitution, be provided by ordinary legislation? The example I gave you was an extreme example.
No,
the first question is, can by ordinary legislation an appeal be provided where the Constitution specifically does not against orders passed by the
I will add to this question. Is there any provision in the Constitution preventing
जो वो टेस्ट है कि जी वो आइटम 55 का कि जी वो हमने तो इनलार्ज किया, पहले एक अपील थी अब हमने दूसरी कर दी है, तो इसलिए ये हमारी कॉम्पिटेंस में है. Would that argument stand?
Noted, my lord.
आप बाद में जवाब दे दें, आगे बढ़ते हैं.
ऐड कर रहा हूँ उसमें दूसरी तरीके से. Is there any provision in the Constitution preventing the Parliament from doing so.
It's noted, my lord. Now, my lord, if my lord may kindly turn to Article 191. Let's go to Article 191. It has been read out. I'll just read the first part of it, where it says, subject to the Constitution and the law.
Mr. Attorney General, Mr. Attorney
My
General,
lord.
please you read just the preamble of this act and section 3.
Yes. Yes, my lord, it has been read out.
Talks about Article 10A.
Article?
10A.
Yes, it does.
Specifically. And Article 4, Article 25.
My lord.
And subsequently in section 3 specifically talks about 184.3.
My lord.
How this can
It does-
be
it does not-
proceeded
Three,
under
yes.
Article 199 when specifically it is challenging the mandate of the Supreme Court as per section 3 of this act.
My lord. How?
How that can be moved before the Supreme High Court under Article 199 of the Constitution.
My lord, I noted. My lord, now the question that has come before your lordship is whether this Act, 2023 Act, is covered under the definition of law, howsoever expansive definition, howsoever expansively the term law is defined. My lord, Article 260 has two definitions. One is of an Act of Parliament and the other is of a federal law. Here we are dealing with the federal law. Article 260 defines a federal law. It says,
You say over here, law includes statute law.
yes,
Point.
yes. In my respectful submission, law can only have one meaning as far as this provision is concerned. But even if it is given an expansive meaning, this act would surely be covered under the definition of
But
law.
if it's to be covered, then why didn't the Constitution say by an act of Parliament? Why did it use the word law? These words are not interchangeable. They are used in a very specific sense in different articles, and so you have to, the interpretation has to be given to the word law and not to just say just because law includes legislation, so here it will be legislation alone. Law has a meaning, and if the Constitution wanted to say it just by an act of Parliament, it would have used those words.
Your Ladyship, when we look at the provisions from where the Parliament draws its
Why did you look at 75.3?
जी 75.3 and 141 and 142 as well.
पढ़ लेते हैं जरा उसमें दोनों लफ्ज इस्तेमाल हो गए.
When the President has assented or is deemed to have assented to a bill, it shall become law and be called an act of Majlis-e-Shura. So
Law
it is.
happens. What it is, the name of the thing is, you are a man. Your name is Mansoor Rahman. I would read it like that.
And the definition of federal law under Article 260 is federal law means a law made by or under the authority of Majlis-e-Shura Parliament. Now, if we turn to Article 8.2, for the sake of this submission, where any law which is inconsistent with fundamental rights is void, Article 8.2 says the state shall not make any law. Now, the state is not just the Parliament, the state is the province, the governments and the assemblies and any authority which has the power or is authorized by law to impose any taxes.
आप फरमा रहे हैं कि law and you refer to the definition of federal law. You don't say federal law. It says
It does not. What I'm saying is,
I have a question for you. Suppose provincial assembly under Article 191 law बना देती है, बना सकती है.
तो 2000 के अंदर 2000 Supreme Court deals with that question. Yes, they cannot be answered. Because the power with respect to legislation with respect to regulating the court's jurisdictions or powers flows from entry 55, so 191 or 175 too, for that matter.
I draw your attention to entry 50.
Relates to the federation also. Yes. Ji.
Kindly read it.
Ji. Matters which under the Constitution are within the legislative competence of Parliament or relate to the federation.
So therefore it seems to me, and I put it to you as a question, that actually entry 55 has nothing to do with Article 191. the power that is specifically conferred on Parliament to make statute law, and in terms of Article 191, is relatable to Entry 58. Entry 55 has got nothing to do with Article 191. And this connection, first of all, excludes the example that I gave of a provincial assembly making a law over here, right? And secondly, it establishes that here
the intent of the
And this is where the principle
constitutional law.
My lord,
आप जरा please, if you don't
if I
mind,
may, I have to take your lordship to
आप
now
जरा please
order.
proceed further. I mean, we will write a judgment whatever we want to write.
Now, my lord, I will. My learned colleague will be recording the questions, noting down the questions, and I'll respond.
One thing, how I understand this. This is not my statement.
Rahman knows shorthand.
This is not my statement. This is my understanding. Act of Parliament can be considered as law as well. But every law cannot be considered as act of the Parliament. जैसे कि आप मिसाल लेते हैं, landlord can be landlord, but owner can be treated as owner as well as landlord. तो इस तरीके से ये जो legislation है, Parliament करती है, उसको आप law भी कह सकते हैं, act of Parliament भी कह सकते हैं, लेकिन जो judgment या case laws से आते हैं या customary law होते हैं, उसको आप act of Parliament नहीं कह सकते, तो इसलिए उसको confine किया गया, law किया गया.
कह भी नहीं सकते, my lord. और दूसरा एक और just let's look at it from another aspect. Now, 1980s when these rules were made, and when these rules were made, if I draw your attention to Order 11, Order 11 को जरा देखिए.
अगर हम बहुत ही pedantic approach ले
Order 11, my lord.
ये pedantic approach ले लें, ये किसने बनाए? किसने बनाए?
Supreme Court ने.
कब?
1980.
Supreme Court क्या होती है? नहीं, hang on. If you go into that approach, Supreme Court क्या होती है?
All the Chief Justice and the judges
sitting at home? No, where? Yes. No, but if you're going to go that route, then you can even say these are what is they say Supreme Court can make, not administrative meeting of the judges of the Supreme Court. Where does the Constitution provide for an administrative meeting of the judges of the court? So we don't want to just destroy the entire system of governance So did we sit in a court of law? Did we pass a judgment? How did these rules get enacted? Did people have a say in the matter? Or 10, 15, 17 people, then all gentlemen got together in a closed room and say, here, where is the concept of an administrative thing? That administrative concept itself is created by the rules. So it cannot supplant the constitution itself. It says the Supreme Court. It's very clear. Now, I am not really understanding. I am only concerned with one and only one thing. What have we taken away from Khwaja Sahab, his client, or any citizen of Pakistan? What have we taken away? What have you taken away? If you've taken away something, we will strike it down. I mean, I don't know why we are having this academic discussion. I really don't understand the point.
My Lord, if I may. Now, there is this provision under this law, and Section 7, for example, application for fixation of urgent matters. Do we not know that there are
Can these rules be challenged? I think they can be challenged. If they had a supra-constitutional effect, they can't be challenged. Suppose tomorrow I refuse to fix any bench. What will compel me? At the moment there is stay order of reason, I said, nahi, hum chutti pe jaate hain. Hum court hi nahi lagate hain. What will you do? Move a reference against me, that's about all. You can't compel me under any law to do that. So, the object is, there has been a problem, there has been successive addition of cases, we are completely closing our eyes to it. हम 2019 में full court meeting हुई थी, वो भी हम नहीं कॉल कर सकते, वो भी इख्तियार चीफ जस्टिस का है। 2019 से 4 साल गुजर गए हैं, क्यों नहीं मीटिंग कॉल हो रही है? 2019 से उस जमाने में 40,000 केसेस थे, अब उसमें ऐड हो गए 27,000। हमारी मर्जी, हमारा डोमेस्टिक अफेयर है? नहीं, हमारा डोमेस्टिक अफेयर है, फिर हम तनख्वाह नहीं लें स्टेट से। हम टैक्स पेयर हमें पैसे देता है, हमें एक काम के लिए पैसे देता है, केस का फैसला करो, ये हमारा काम है और कोई काम नहीं है, बाकी सारे हमारे पेरिफेरल काम है। तो ये आप इतने आप उस मेन पॉइंट पे आप नहीं रह रहे हैं, आप ही खिसक रहे हैं उधर, वो भी मेन पॉइंट पे नहीं आ रहे हैं।
My lord, I just
ये जो आप पढ़ रहे थे
rephrase
कॉन्स्टिट्यूशन ऑफ बेंचेस का,
जी,
उसको पढ़े ना, ये सेम एज अदरवाइज प्रोवाइडेड बाय लॉ।
जी, सो
तो कोई लॉ था नहीं
जी, उस वक्त नहीं था। रिकग्निशन ठीक है, लॉ प्रोवाइड कर सकता है कुछ
नहीं। आपसे ये अभी देखिए, हम
उस वक्त लॉ
क्या ये आपके ख्याल में ये जो 1980 के रूल्स हैं ये लॉ है?
My lord, these are
आपसे सिंपल, आर द 1980 रूल्स लॉ, कम विद इन द पर्व्यू ऑफ लॉ?
191 की डेफिनेशन क्या आप नोटिस कीजिए? No sir,
no,
these are the rules.
These are the rules. The language says subject to the and the law, the Supreme Court will make rules.
What is the purpose of mentioning save as otherwise provided by law?
Yes, this is the recognition of what Article 191 provided. Now, at that time, there was no statute or an act of parliament which provided for anything, but the full court of this court left it open.
Now the law has been promulgated, and this covers under this provision.
Yes, not just this provision, it is covered under 191. This only recognizes what 191 already
Mr. Attorney General, then you are excluding all those laws which are made under the delegated powers. You are excluding all those laws which are made under the delegation of the power by the government or the parliament. Delegated legislation.
In what context, my lord?
In the context of definition of law. There are two primary law and the delegated law. And delegated law includes the rules.
No, we are looking at
the Supreme Court rules are not law.
We are only looking at the language of 191. We are looking at the language of 199, and we are trying to.
I have committed a mistake.
Article 191 redundant where it says subject to law. And redundancy cannot be attributed lightly to a statute, let alone a constitutional provision. The judgments are in the paper book. My lord, there was another submission which was made with regards to field being occupied, which is to say that since the rules had been made, therefore the field stood occupied and therefore a law cannot be made. Now, that principle also does not apply because that principle is only applicable where the powers are coextensive or coterminous. Here, the Constitution specifically says that the rules shall be subject to the Constitution and the law. It can't be. So, therefore, the doctrine of occupied field does not get attracted here. Now, my lord, if I may take your lordships to the individual provisions of the statute before I conclude my submissions. Section 2, my lord. Section 2, as I've already submitted, it endeavors to create more transparency, where the power has been, which was under the rules vested in the Chief Justice has now been
Call it a sharing of the burden.
sharing of
It's
the
a
burden.
huge burden.
Yes.
Why think of it negatively? Think of it positively.
accordingly.
It might not.
तनख्वाह ले रहे हैं इस गरीब आवाम से एक काम करने के लिए कि उनके केसेस का फैसला कर लें, खत्म। ये बहुत अच्छी डिबेट है, जाके हाई कोर्ट में कर लें चैलेंज, वो आ जाएगा जजमेंट नंबर 94 में, हम बड़े पूरे पावर्स के साथ बैठ के इसको देख लेंगे। आपको पता है आज बेंच बनाने का क्या इशू था, इसके बावजूद के स्टे चल रहा है। मैंने अपने 2 सीनियर कलीग से पूछा कि मैं ये करने जा रहा हूँ, 2 स्टे चल रहा है, अलग बात है आइन कानून पर स्टे चल रहा है, फिर भी कि बात को आगे बढ़ा के किसी खत्म कर लेना, सराह लें कानून को, ये तर्क कर दें, मगर आप अपने दलाइल दें, हम उसका सुन लेंगे और फैसला कर लेंगे। कोई इख्तलाफ करेगा, कोई नहीं करेगा, उनकी मर्जी है। हमें आपको परसुएट करने की कोई जरूरत नहीं, आप हमें परसुएट कर लीजिए, और सवाल का जवाब नहीं देना चाहते मत दीजिए, हम आपके खिलाफ कर लेंगे फैसला।
My lord, my learned friend is question.
No, sorry. I'm not indulging in conjectures.
My lord,
I'm asking you a question in order to understand the principles that you are saying and arguing and submitting before the court.
my lord,
I'm not engaging in theoretical argument.
my lord.
I'm trying to understand the basis on which you are defending the
My lord,
constitutionality of this law.
आपका सवाल।
So therefore my question stands. Tomorrow if Parliament were to make this a law and say, let it go back to the Chief Justice in his sole capacity.
So the object is, there has been a problem, there has been successive addition of cases, we are completely closing our eyes to it. हम 2019 में full court meeting हुई थी, वो भी हम नहीं कॉल कर सकते, वो भी इख्तियार चीफ जस्टिस का है। 2019 से 4 साल गुजर गए हैं, क्यों नहीं मीटिंग कॉल हो रही है? 2019 से उस जमाने में 40,000 केसेस थे, अब उसमें ऐड हो गए 27,000।
My lord, I just
जो आप पढ़
just
रहे थे
rephrase something.
कॉन्स्टिट्यूशन ऑफ बेंचेस का,
जी।
उसको पढ़े ना, ये सेम एज अदरवाइज प्रोवाइडेड बाय लॉ।
जी। So
तो कोई लॉ था नहीं।
जी, उस वक्त नहीं था। रिकग्निशन ठीक है, लॉ प्रोवाइड कर सकता है कुछ।
नहीं, आपसे ये भी देखिए हम
उस वक्त लॉ
as a master of the roster, could decide whether to take a suo motu or not. Why not a committee?
Yes, and that is why my response was
is
that
further
if
providing guarantees. And my only question is, are we not accountable to the litigants?
absolutely
The Parliament is the representative of the litigants. If they want to change our procedure because they are not satisfied with our internal or institutional independence, that's their prerogative.
and
We are
if I
there
may,
to serve the litigants.
and if I may, my
But
lord,
normally, you see, the cases would be marked by the Chief Justice, even if it's a 184.3. So I think the question of judicial power is secondary. First comes the constitution of the bench, and then judicial power is going to be exercised. Here we're talking about the constitution of the bench. It doesn't impair any judicial power. The question is, earlier the Chief Justice would mark the case to somebody. He would certainly mark it. I mean, I as a judge would not hear any case unless it's marked to me. And then all it says is that instead of the Chief Justice, the committee marks it.
Section
So judicial
3, my
power
lord.
is not in any way impeded because judicial power comes after the bench. is
Section
marked.
3, Section
No, you
3
see,
talks
Section
about
3
invoking of jurisdiction, and that is what I was
Section 3
addressing.
specifically states that the committee would examine. ये देखिए the word
जी,
used
जी,
is
and that's what I was
examine.
addressing.
After for examination, if the committee is of the view that the question of public.
This is exactly
So
what
it's
the
a
Chief
judicial
Justice-
power.
Yes. So मैं
So
यही
how-
कह
Administrative side exercise judicial power.
मैं यही आपको कह रहा हूं कि if you are minded to hold कि ये जो ओवरलैप हो गया है कि एडमिनिस्ट्रेटिव फंक्शन और जुडिशियल फंक्शन को कंट्रोल कर रहा है, you would have to inevitably hold that going forward there will never be a suo motu exercise of powers, because that's exactly what the Chief Justice to do. They would first examine it and then constitute a bench, और यही वो टेंशन थी जो आप पैराग्राफ
Please take one question from this side, AG sir.
Oh, sorry.
The Article 184 begins with the word Supreme Court. What does that mean? Supreme Court means all the judges or only the Chief Justice?
It's what Article 176, your ladyship, says is the Chief Justice and the judges of the Supreme Court.
184 I'm talking
जी
about.
तो 184 में जो सुप्रीम कोर्ट है, सुप्रीम कोर्ट को जो है वो 176 से फ्लो करेगी.
जी
176 में सुप्रीम कोर्ट का मतलब है चीफ जस्टिस एंड ऑल द जजेस.
All the judges.
No single person is the Supreme Court. It's all of you who are the Supreme Court. So while exercising jurisdiction, अब ये हो सकता है कि आप ये कहें कि नहीं, ये सेक्शन 3 जो है ये इस तरह से नहीं होगा, इसको हम रीड डाउन करेंगे और कोई भी एक्सरसाइज सारी कोर्ट बैठेगी और वो पहले देखेंगे कि ये थ्रेशोल्ड मीट होता है या नहीं होता है, and then
You mean to say that
committee that could be
Mr. Attorney General, the committee is constituted of 3 members to see whether the case do fall within the ambit of 184.3 or not. The litigant would be invited to argue, or that would be only seen by the members of the committee themselves. If 2 out of 3 comes to the conclusion that it is not a case fit for to proceed with Article 184.3, would it not be defiance of right of audience and the Article 10A and all other due process?
इसमें
in continuation, and what remedy would be available to him, because this is an administrative order, it cannot be challenged in appeal except the chamber appeal under the rules.
Mr. Attorney General, Section 3 is not actually saying that he's going to dismiss a petition at the administrative side. It's simply saying we look at the petition as the Chief Justice looks at the petition. He looks at it, it says a 184.3 petition, he marks it to a bench. It is not saying there is no consequence. Suppose he thinks there is no question, he'll mark it to some other bench. It doesn't say he'll dismiss the petition as to give a hearing to anybody. It is just to look at the
My
file.
lord, ये जो threshold है administrative side पे day in day out basis पे हमें cross करना पड़ता है litigants on this side. जहाँ पे objection आ जाते हैं registrar के कि जी ये meet नहीं.
What's been happening? Number of 184.3 petitions have come up that the office has put objections. Yes. Not the judge, the office.
Yes.
जी one very low.
बिल्कुल.
ठीक है, उन्होंने objection लगा दी, not does not come within a
उसके chamber appeal में जाना पड़ता है.
They've come to me some of the absolutely ridiculous kind of petitions. ठीक है, they're dismissed. Against an appeal is filed. The fact that you don't make available 184.3 does not mean you can't file a civil suit, does not mean you can't file an FIR, does not mean you can't go to 199, does not mean any other remedy. So this is done every day, we do it. Not 3 judges, 1 assistant registrar in the branch office says not maintainable, उसके खिलाफ अपील आती है. वो कितने लोग सुनते हैं? 1 जज. उसके खिलाफ क्या अपील है? कुछ भी नहीं है, एंड ऑफ स्टोरी। ठीक है, तो यहाँ वो भी जुरिडिक्शन बढ़ गया है। वो आपने हमें वो असिस्टेंट रजिस्ट्रार के पास हमें दे दिए हैं, उसके पास होना चाहिए, असिस्टेंट रजिस्ट्रार के पास तो रहने दें उसके पास, वो बेशक बेहतर तयन कर लेगा, जो खुश नहीं होगा वो अपील में होगा। अब तो ये तो बल्कि ज्यादा उसको अहमियत दी जा रही है, रादर देन उसको निगेट कर रहे हैं। और राइट तो नहीं है 184(3) का, राइट आपके सारे महफूज हैं, जो आइन देता है, जो कानून देता है। ये नहीं कि आपने 184(3) की पिटीशन डिसमिस कर दी, 99 में आप नहीं जा सकते हैं, या आप सूट नहीं फाइल कर सकते हैं, जो भी चीज। यहाँ तो लोग अजीब अजीब चीजें, जी मेरा इससे पैसे उधार है, वो जाके 184 डाल दिया उसने, हमने उसको डिसमिस कर दी। रजिस्ट्रार ने राइटली मेंटेनेबिलिटी भी किया, अपील है, हमने उसको डिसमिस कर दिया, इवन दो जस्ट वेस्टेड अननेसेसरी टाइम ऑफ अ जज ऑफ द एंटायर स्ट्रक्चर ऑफ द सुप्रीम कोर्ट। तो आई डोंट नो what are we taking away? Back to the same question, what are we taking away?
इसमें इस वक्त
उसमें तो और ज्यादा फिर प्रॉब्लमेटिक है, बिकॉज उसमें तो खुद ही कर रहे हैं, वो खुद ही एग्जामिन कर रहे हैं।
इसमें भी 3 में भी the process is that if the committee thinks that it's a matter of 184(3), they'll mark it to a bench which is not less than 3. If they think it's not, they'll send it to a 2-member bench maybe, or whatever. It's not throwing out the list.
And my lord, as my lord the Chief Justice has just observed, it is not that other than 184(3), the constitution of this country or the laws of this country do not provide any remedy.
May I add to this?
My lord.
All that the committee will be doing, raising an objection.
Yes.
Objection to the effect, and that is for us internally to provide an appeal against
My
that.
lords can suitably amend the rules and
See, again, the question is that since 1980 had not amended our rules, that is why the parliament was forced to amend them. Had we amended them ourselves, because the bars were raising questions, the public was raising questions, the litigants were raising questions, we actually forced the parliament to do it for us. And everyone, there's consensus that this is exactly. अब इस वक्त हम सिर्फ ये कह रहे हैं कि बहुत अच्छा काम है, पार्लियामेंट ना करती, आप कर लेते. But what when
or a fourth appeal or a fifth appeal.
It's the parliament. Parliament won't do absurd things, and
No,
of
it's
course,
it's not a question of absurdity because this undercuts the review, the whole concept of review. The finality of judgments or res judicata is regarded as one of the most fundamental principles of the administration of justice.
Surely does.
Exception. No, अगर आप बात कर रहे हैं तो ये तो फिर infinity हो गया.
नहीं, infinity नहीं है. Obviously, we're talking about the parliament here. We're not talking about.
आप बात फिर आ जाती है conjecture और theory और ये और वो बात principle की हो रही है. असूल समझने की है ना. एक दफा एक बात को concede कर दिया जाए, accept कर लिया जाए. In principle.
This play. And I submit that entry 55 sufficiently covers section 5.
Can you go to the next point?
Ji.
I'll only add to this, learned Attorney General, there's a distinction. Article 185 explicitly is for those judgments that are rendered by the lower courts. Here the appeal has been provided in 184.3, which is our original jurisdiction. And it's only of a supplemental nature. It's a continuation of the same proceedings, the original jurisdiction.
And,
so I don't see how...
And in a context where this court becomes the first and the final court in the same proceedings.
That's done. Are you done?
My Lord, to this extent, and I'm just going to conclude my other two submissions here. I have placed on with my paper book the judgments of in Baz Mohammad Kakad case and the Punjab Provincial Cooperatives case. They are in volume 2, my Lord. My Lord, section 6 now, right to...
there was one concern also expressed by Justice Aisha Malik, which was that if we follow this procedure, then when the full court meets, then the appeal goes away. एक ये भी point था, इसको आप कैसे address करेंगे? Because I mean, one answer could be if the wisdom of all is such है, तो फिर वो naturally सब लोगों ने सारे एंगल देखे होंगे. आप कैसे address करना चाहते हैं?
उसमें एक ये बात है, मैंने अपने written submissions में ये कहा है कि आप इसको to that extent read down कर लेंगे.
इस हद तक read down करें.
जहाँ पे full court होगी naturally appeal जो है literate हो जाएगा. But आप उसको ये कर सकते हैं. Sorry sir. Just
I'm saying if you harmonize 4 and 5 in a situation where the whole full court is hearing it, the question of appeal does not arise.
My Lord, ये अब 15 बैठे हुए, so मैं जैसे just will say, so if it was in original proceedings it was a bench comprising of 7 lordships on this side, the appeal would have come before the remainder 8 judges because it had to be a bench larger than the bench hearing the original appeal. In this case, we are before your lordships in original jurisdiction, full court.
इसमें ये जरूरी नहीं है कि one jumps from 5 member to full court. फर्ज करें अभी 15 जज हैं, ठीक है ना? फर्ज करें एक आर्टिकल 184(3) की जजमेंट वो पिटीशन आ जाती है, 9 member bench बन जाता है. फुल कोर्ट तो नहीं है.
My Lord would be mindful of this.
अब ये हो सकता है आप कहते हैं यहाँ पे जी वो चीफ जस्टिस मास्टर ऑफ द रोस्टर है तो ये खराब और वो खराब और ये खराब. फर्ज करें 3 member कमेटी कहती है जी हम भी उसमें बैठ सकते हैं, हम राइट ऑफ अपील खत्म कर देते हैं, हम 9 member बेंच बना देते हैं. आप देखिए ना, आप इसको एड्रेस कीजिए ना. ये ऐसी बात नहीं है कि द विजडम ऑफ द फुल कोर्ट आ गई तो राइट ऑफ अपील तो खत्म हो गया.
What I'm submitting is that now it's a duty cast हो गई है इस कमेटी के ऊपर.
पर उसी तरह ड्यूटी पहले चीफ जस्टिस पर भी थी ना. नाउ यू पुटिंग द ड्यूटी ऑन द फुल कोर्ट, तो कोर्ट तो फिर अपनी मर्जी पर ही चल रही है ना. व्हेनेवर इट वांट्स टू डू समथिंग वो राइट ब्लॉक करना चाहेगी. व्हाट यू आर सेइंग इज दैट सब्सटैंटिव राइट दैट यू हैव क्रिएटेड अंडर द स्टैट्यूट is again left to the mercy of the court. It will decide कि ये substantive right देनी है कि नहीं. तो फिर आपने ये right दी किस मकसद के लिए दी?
8 member bench बन जाए, 9 member bench बन जाए, right of appeal खत्म हो गया.
So let me just
I think what we can do is we can logically interpret the legislation. Now, for instance, when this case was first being heard, it was an 8-member bench. There were not enough judges still aren't to have heard an appeal, theoretically speaking.
Yes.
So, unless the bench, the very first day it sat, it decided to strike out this law. That's a different thing. But if it was sustainable, then how could an 8-member bench be constituted to begin with? Just because that right of appeal was taken away from day one the bench sat. We are now worried about the right of appeal when there is a full court, but this question should have been raised against those, or when the bench was being constituted, that the law provides for a right of appeal. Here we are 8 of them. There aren't 9 of us available. So how that right of appeal has already gone away. We have decided an important component of this law. Before sitting in the courtroom, we have decided it. Is that correct?
Yes.
So when we are concerned now, we should have been concerned earlier too. So वो तो गई.
Actually जब वो CMAs थी full court के लिए जब आर्ग्यू हो रही थी तो उस वक्त ये सवाल बकायदा उठाया गया कि आप कह रहे हैं फुल कोर्ट बनाई जाए, आपको तो कहना ही नहीं चाहिए कि फुल कोर्ट बनाई जाए, आपको तो कहना चाहिए दिस मैटर शुड बी हर्ड बाय लेसर नंबर. वो CMAs क्योंकि वो हेयरिंग पे नहीं गई,
But the burden at the end of the day was on us.
The question was in fact put by me.
Lord,
And so therefore it's not that the question was not there.
My Lord, if I may briefly respond to it, followed by a response in writing.
Let me add to this. Let me add. मेरे ख्याल से जो मैं गदर कर चुका हूँ और ऑर्डरशीट पढ़ने के बाद महसूस तो ये हो रहा है कि जब ये पिटीशन ली गई उस वक्त तो यकीनन बिल था. इट वाज नॉट थ्रू द पार्लियामेंट, एक्ट नहीं बना था. बनने से पहले सस्पेंड होता जो कि आज तक इनफील्ड नहीं है. अगर ये इनफील्ड होता तो शायद 8-member बेंच उस वक्त भी ना बनता. इसका मतलब ये कि हम एक्ट को मान रहे हैं. अगर हम बेंच पे एतराज़ करें इसका मतलब हम एक्ट को मान रहे हैं. और अगर एक्ट सस्पेंड है फिर तो अगर 8 member बन सकते, व्हाई नॉट फुल कोर्ट?
So मैं इसका brief एक response दूँ and then followed by a detailed response in writing. Briefly put, and that would perhaps address ladyship's question as well, but in subject to what we have to submit in writing. Going forward, if this act is upheld and is declared intra vires, the committee at all times would be mindful that there is a right of appeal, a substantive right, which will get obliterated if a bench beyond a certain number, given the numerical strength of the court at a particular time, is constituted. So therefore, that power, that administrative power exercised by the bench.
Mr. Attorney General, इसका मतलब है पार्लियामेंट ने फैसला कर लिया कि जी फुल कोर्ट, सुप्रीम कोर्ट की फुल कोर्ट कभी बैठ ही नहीं सकती.
In cases, in circumstances में ये हो सकता है, जैसे अभी भी है.
Repercussions तो सोचिए आपकी बात की कि यही precisely सवाल है कि इस लॉ की इस सेक्शन की वजह से.
So let me put it differently.
ये
Now,
फुल कोर्ट कभी बैठ ही नहीं सकती.
नहीं, full court आप बैठेंगे.
Article
In exceptional
184
matters,
questions which are the most important question that can ever be raised before the court.
in exceptional circumstances, it
General,
might be so.
Mr.
But
Mr.
does
General,
that is that enough to just take away the right of
Mr.
appeal?
Attorney General, the other way to look at it is that if the committee were to have the view that the matter is so grave and so serious that a larger bench which will not provide for an appeal be made, either full court or any large bench, then that be so. I mean, that is how the committee will decide, looking at the issue. So it doesn't take away the power to constitute a larger bench or a full court, but at the same time, it will be saying that it's so important that a collective wisdom will prevail. So there is no, I mean, doesn't really, it can be easily
It can be reconciled. My Lord, Section 6, right to appoint.
Section 5 can be read down.
My Lord, to that extent, my Lords can hold that in exceptional cases and when situations this sort arises, that be so.
Right of appeal पे substantive right नहीं है जो statute.
Ladyship, look, we are faced with a situation here, and let me just be very candid now. We have had recording, we have had car case, and we have God knows what not, and all of that has happened under 184(3). With great respect, And steel mill is a classic example. Steel mill was in profits at the time when all of that happened, as far as my information goes. It had 12 billion worth of raw material lying there. And now we are faced with an asset which is constantly bleeding.
How many of those were full court? How many of those were full court judgments?
My Lord, may not be.
यही तो मैं आपसे कह रहा हूँ ना.
Not be. मैं ये कह रहा हूँ कि इसको reconcile किया जा सकता है.
यही तो point है कि एक तरफ आप कह रहे हैं हम right of appeal दे रहे हैं in order to address precisely these kind of things. दूसरी तरफ कह रहे हैं कि चलो फुल कोर्ट बन जाए तो बन जाए, कोई
फुल
फर्क
कोर्ट
नहीं
बन
पड़ता।
जाए, मैं ये कह रहा हूँ कि there might be issues in time.
मतलब है आप काइंडली जरा थोड़ी सी
नहीं, मैं there might be issues in time. आप
एप्लीकेशंस ऑफ योर सबमिशन तो काइंडली देखिए।
मैं उसको ये इस तरह से आपको कर देता हूँ कि
देखिए,
आप ये बैलेंस आप रख
अटॉर्नी
लेंगे।
जनरल साहब, लेट्स बी, वी आर ऑल ग्रोन अप्स, राइट?
अटॉर्नी जनरल साहब,
एक कैन आई जस्ट, we, the problem arose, I think thousands of articles have been written, lawyers have spoken about it. We keep talking about the two chariots, but let's place some emphasis on the lawyers also say. There has been allegations, and I can deny it, but it doesn't. Public opinion thinks that 184.3 has been misused, jurisdiction has been exceeded. ठीक है? So what you are saying is, first of all, we did not create the mess. You created the mess. We are trying to solve your mess. What did we do? 3-member bench judgment, 184.3, final judgment. Nothing can be done. Now we are concerned about full courts only. What about the 3-member bench judgment? It was a 3-member bench judgment which did recodic. It was not a full court or even a large bench. A 3-member bench is the normal, smallest bench in the Supreme Court. So what could you do? Nothing. Now you come in advisory jurisdiction, we have to kind of find ways and means because it's the interest of the country at stake. I would rather surrender my high status and place it at the feet of the taxpayer public of Pakistan rather than give them a whopping liability of $6.5 billion because the independence of the judiciary, they'll say, what are you talking about independence of judiciary? Independence of Pakistan will disappear if you labor this much of debt on Pakistan, 6.5 billion. It's not easy, we don't understand the repercussion of things. Fine, I'm not saying that judges who decided that, they did what they thought at the time, how they were assisted according to their conscience correctly in their minds. Yes, but we make mistakes. Suppose I was a member of this bench. I would love this thing if it came to my mind, repercussions. Okay, now there's a right of appeal. I can undo. Review jurisdiction, you know what the review jurisdiction is. Take the case of Zulfikar Ali Bhutto.
Yes.
Supreme Court split. Review unanimous because the scope of review is very different creature. It is error floating on the record, so they didn't even go there. That could not be rectified through review. You had to create 184.3. If आपको simple बोलना चाहिए, अगर आप अपने इतने ज़्यादा काम ना करें, थोड़े हदूद में रहें, शायद हमें इस लेजिस्लेशन की भी जरूरत नहीं पड़ती. हमने भी तो थोड़ी गलतियां कर ली. हमें देखिए हमारा प्रॉब्लम ये हो गया ना, अन्ना बहुत बड़ी बन गई है और तकब्बुर. हमसे गलतियां हुई हैं, मुझसे गलतियां हुई हैं, मान लें गलतियां हुई हैं. ठीक है, हमने ऐसी चीजें की हैं, हमने जस्टिफाई किए मिलिट्री टेक ओवर्स को, मान ले गलती की है. ठीक है, अदरवाइज आइन की कोई हैसियत नहीं है. अगर जजमेंट लॉ हम उसको रख लेंगे अपने ऊपर तो वो तो फिर आइन तो गया, फिर वो तो सारे जजेस थे, उन्होंने सबने एंडोर्स कर दिया. मैं नहीं मानूंगा इसको क्योंकि मैंने हल्फ नहीं उठाया है. The minute I say that, please file a reference against me that I'm violating my oath of office if I say even this, कि I will endorse these subsequent acts. मुल्क का भी तो सोचना चाहिए. हमें अपनी सिर्फ अपनी अना और आपको अना और इन ख्वाजा साहब मुझे नहीं बताया उनको क्या मसला हो रहा है, उनको हमारा फिगर पढ़िए. हम स्यूमोटो हर जगह करते हैं, हमने यहाँ क्यों नहीं स्यूमोटो किया? Why are we waiting for him to bring an act? 10 पिटिशंस आ गई, पब्लिक में से तो कोई नहीं आ रहा है. पता क्या मसला है लोगों का? उनके तो कोई मसले नहीं, वो कहते हैं भाई हमारा केस चला के खत्म कर लें. Sorry, I'm diverging, but we have to see the larger picture also. We have to see work within the constitution where every citizen gets his due. What are we doing? What are we taking away from him? Focus on that.
Nothing, my lord. And section 6, my lord.
इसमें अटॉर्नी जनरल साहब लॉ रिफॉर्म्स ऑर्डिनेंस के तहत देयर इज अ राइट ऑफ अपील, लेकिन कई केसेस में डिपेंडिंग ऑन द इश्यूज द हाई कोर्ट्स कॉन्स्टिट्यूट लार्जर बेंचेस एंड देयरफॉर दैट राइट ऑफ अपील इज नॉट अवेल. लेकिन जहाँ तक देखें ना, जो अभी बात हुई है 184.3 इज डिस्क्रेशनरी. नाउ यहाँ पे जितनी बात हुई है, इवन दी petitioners, their counsels, they all agree that this law is in the interest of the litigants. It actually enhances access to justice. So why shouldn't we just not exercise our jurisdiction because in exercising jurisdiction, we will be going against the interests of the litigants. Why should we go against the rights of the litigants? It is in their interest and in their favor.
ये जैसा एक प्रॉब्लम अभी जो अपील के बारे में बात हो रही है, कॉन्स्टिट्यूशन हैज आंसर टू इट. सपोज आज हम 15 बैठे हैं, कल 2 वैकेंसीज है वो भी फिलअप होती है, 17 के 17 बैठते हैं. इशू यहाँ पे ये कि अपील की रेमेडी नहीं हो, इस एक्ट के तहत अवेलेबल नहीं हो. लेकिन कॉन्स्टिट्यूशन कहता है आर्टिकल 181 में जब ऐसी सिचुएशन आ जाए तो अ जज फ्रॉम द हाई कोर्ट कैन बी आस्क्ड टू एक्ट टेम्परेरीली एज जज ऑफ द सुप्रीम कोर्ट. तो वो आपका एक्ट कहता है कि लार्जर बेंच विल हियर द अपील. सो एड वन जज, दिस इज लार्जर बेंच, अपील इज देयर. No problem. I think problem is solved by the constitution.
The remaining judges would be the same. फैसला तो वही आएगा.
This will just like review.
आपने conclude कर लिए.
My lord, I just now the section, as far as section 7 is concerned, I've already submitted. I think this provision surely addresses the concerns of the litigants, fixation of cases. Under section
provision
7
of intra-court appeal, that is to be seen. Intra-court appeal जो आपकी है, उसको देखना है.
इधर सिर्फ प्रॉब्लम ये जो आपने रिट्रोस्पेक्टिविटी दी है इस लॉ को, उससे हमारी पेंडेंसी और ज्यादा नहीं हो जाएगी.
My lord, at one end, now my lord would have to
देखिए
see
हम सारी बात चलें, ठीक है, मान लेते हैं जी, आप इंटरेस्ट कर रहे हैं, उधर आप उसको रिट्रोस्पेक्टिव, अब आप सोचिए 185(3) का और आप इस तारीख से दे रहे हैं, यू गोइंग बैक अप, व्हाट डू यू एक्सपेक्ट अस टू डू देन? The whole will be gutted.
how many cases would there be, my lord?
And no limitation period is here.
ये तो आप ना करें ना.
My lord,
ये थोड़ा
I
सा
think what has been what we
ख्याल रखा करें ना. आप रखिए, आप लाएं
what the parliament
लाएं,
has,
चलो ठीक
my
है.
lord, what the parliament has tried to address here is
So you see, it is very open-ended. Prior to the commencement of this act, so it will go to 1947 or what?
जितने 185 73 से शुरू हो जाएंगे.
my lord 1947 तो नहीं 75 में पहला हुआ था.
एक बात है, आप इसमें
88
is
में आ गया
open-ended
था
ना.
दूसरा, and then
You have fixed a limitation of 30 days for filing appeal prior to commencement of this act. Means all previous decisions, all persons can come to this court within 30 days after the sustaining the.
I think 30 days have expired. I don't know how many came
ये
actually.
बताइए अटॉर्नी जनरल साहब,
जरा ये मालूम करें दफ्तर से कि इस इनैक्टमेंट के बाद
law was
अपील कितनी फाइल हुई है इस प्रोविजन के तहत?
वैसे नहीं हुई होगी because the law was
सस्पेंडेड. ओके ओके.
couldn't have taken effect.
फिर एक और छूट जाएगा ना. ये बताइए, जितनी दफा इस कोर्ट ने मार्शल लॉज को और डिक्टेटर्स को वैलिडेट किया, कैन द पीपल ऑफ दिस कंट्री फाइल अपील्स एंड have those judgments annulled? Why not?
I would hope so.
I think this is our accountability. Let us be open about it. Why do
And
we
my lord,
fear
just
if
to-
it's
Otherwise,
history,
we'll
I
be brushing
think-
things under the mat.
1975 Manzoor Alai was the first case under 184(3) and thereafter after 13 years it was Benazir Bhutto case 1988. ज़्यादा जो jurisdiction exercise हुई है वो perhaps
But where
पिछले
do you
15
draw
साल
the
में
line?
हुई है.
Where do you draw the line? I mean, the question is, if there is transparency, then let it be.
Let it
Why
be.
brush something under the mat and look into some? Why?
My lord,
Let's undo Federal Shariat Court Maulvi Tamizuddin Khan case. Effectively, it won't mean anything, but maybe it will look good. I don't know. Because everybody's dead or whatever, long past. Go on.
my lord, I would conclude my submissions with this. I have the written submissions along with reliances. I have noted down one question जिसका detail में
ये
हमने
सेक्शन
submission
6
करना
पे
है.
भी बता दीजिए लर्नेड अटॉर्नी जनरल
My
की
lord.
जो आपका
Right
राइट
to counsel.
Yes, because it
Now-
is already covered under Article 188 of the Constitution.
उसमें order 26 है.
Power of the review.
जी, order
So you
26.
have said that the party shall have the right to appoint counsel of its own choice.
पहले जरा my lord का 188 पढ़ लें जो refer कर रहे हैं my lord.
188 is the Supreme Court shall
पढ़ लें जरा.
have power subject to the provisions of any act of parliament and of any rules made by the Supreme Court to review any judgment pronounced or any order made by it.
Yes.
So this power under the power of review
सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ दरखास्तों पर समाअत। चीफ जस्टिस काजी फाइज ईसा की सरबराही में फुल कोर्ट समाअत कर रहा है। तारीख में पहली बार फुल कोर्ट की समाअत पीटीवी न्यूज और पीटीवी नेशनल पर बराह रास्त नशर।